Okay, part two of courts. There have been several legal cases that affected our court system. The first case was Marbury v. Madison. This established the judiciary as equal to the executive and legislative branches of government. The issue in this case was a rather minor decision concerning whether William Marbury should be given a commission as a justice of the peace, as President John Adams had ordered. Because of an error, Marbury did not receive his commission, and the new president, Thomas Jefferson, ordered that the commission not be delivered. Marbury did not get his commission, but the case is famous because Chief Justice John Marshall established the principle of judicial review. Marshall said that the case violated the Supreme Court's constitutional jurisdiction, which was a primarily appellate court. The Supreme Court acts as a trial court when there are cases between states or cases involving a foreign ambassador or minister or the citizen of another state. I think I've listed all of these. And also, Marshall initiated the practice of presenting the judge's decisions as collective rather than separate opinions with written statements stating why the court reached the decision it did. The next case is McCulloch v. Maryland, and this was a banking case. In 1819, it established that the court could find that the Constitution included implied powers that could be deduced from its nature and language. This decision is the basis for the expansion of the power of the federal government into areas such as banking and social programs aimed at the welfare of people. Maryland wanted to put a tax on every note issued by the Second Bank of the United States and all banks not chartered in Maryland. The court found that Maryland was specifically targeting the U.S. Bank. In a series of cases between 1816 and 1821, the Marshall Court upheld the clause of the Constitution reaffirming the superiority of federal law over state law. The cases concerned the sale of land and the right to conduct a lottery. These cases established the Supreme Court as the court of last resort. This is the Supremacy Clause. The next Supreme Court battle was over rights of freed slaves. While Congress passed laws that enfranchised the newly freed slaves, the court supported the Southern courts in areas of voting, jury service, and public accommodations. Plessy v. Ferguson in 1896 formed the basis for a system of apartheid, equal but separate, as well as the rest of the Jim Crow laws of the South. Louisiana had passed a law requiring separate accommodations for blacks and whites on railroad cars. This upset a group of New Orleans residents who wanted to repeal the law. They eventually persuaded Homer Plessy to participate in an orchestrated test case. Plessy was born a free man and was 7/8 of Caucasian descent and 1/8 African descent. Under Louisiana law, he was classified black, so he was required to sit in the colored car. He bought a first-class ticket and boarded a whites-only car of the East Louisiana Railroad. The railroad company opposed the law because it would require them to buy more rail cars, and they knew about Plessy's racial lineage. The committee hired a private detective who had arrest powers to detain Plessy. The committee wanted to make sure that Plessy was arrested for violating the Separate Car Act as opposed to vagrancy. Plessy argued that he had been denied his rights under the 13th and 14th Amendments. The judge, however, said that Louisiana had the right to regulate railroad companies that operated within state boundaries. Plessy was convicted and ordered to pay $25. His case eventually found its way to the Supreme Court. They found They found in favor of Louisiana, saying that separation of the races was a matter of public policy, and Louisiana had not violated Plessy's rights. Separate but equal didn't begin to change for another 50 years when President Dwight Eisenhower nominated the former governor of California, Earl Warren, to be the Chief Justice of the Supreme Court. Warren was a Republican who was expected to steer the court towards conservative values. What a surprise when the Warren Court earned their reputation for championing the causes of the unpopular and marginalized classes of society. Well, he was a Californian, so there you go. Lest you think that the court stayed liberal and free of influence of political parties, the decision of 2000 concerning Bush v. Gore case illustrates the opposite. Let's see what we have next. Of the 9 justices, 7 had been appointed by Republican presidents. The court voted 5-4 in favor of Bush, which indicated not only the conservative leanings of the court, but also the influence of parties. This was a clear example of how important the president's ability to nominate candidates for vacancies in the court. The Supreme Court is, after all, a political institution. Barack Obama successfully nominated 2 women to the Supreme Court, Elena Kagan and Sonia Sotomayor. There was speculation in 2009 when Ruth Bader Ginsburg was diagnosed with pancreatic cancer that Obama would have the opportunity to nominate a 3rd justice. However, her cancer was detected early and she was still on the court. There are 2 important my mind just went blank. We have 2 more justices that were appointed by Trump. Names I can't remember right this second. There are 2 important court issues: jurisdiction and organization of the courts. This slide, there are 3 types of jurisdiction. Okay, let me start that again. There are 2 important court issues: jurisdiction and organization of the courts. There are 3 types of jurisdiction. One is based on seriousness of crime, and the other location of the crime. The last one is whether or not the case is an appeal or not. We have a dual court system in the United States. Federal courts and state courts. Federal courts include magistrate courts, U.S. district courts, U.S. circuit courts of appeal, and the Supreme Court. The magistrate judges are appointed by a majority vote of the federal district court judges in a particular district and serve 4 to 8 years. They support the federal judges and can conduct judicial proceedings of a minor nature to expedite the disposition of civil and criminal caseloads of district courts. They conduct primary hearings, appoint counsel for those who cannot afford their own lawyer, set bail, and issue search warrants. They also handle misdemeanor cases and accept pleas. District courts of general jurisdiction handle more serious felony cases involving federal laws and civil cases that involve issues whose final outcome could be more than $75,000. There are 94 district courts, 89 in the states and 5 in the territories of Puerto Rico, Guam, and the District of Columbia. Each state has at least 1 district court, but some have more. However, no district court jurisdiction crosses state lines. Judges for these district courts are appointed by the president and confirmed by Congress. The circuit courts of appeal originally began in the 13 colonies, where they served as trial courts and appellate courts. Currently, they serve as intermediary courts between district courts and Supreme Courts. Like the Supreme Court, they can issue a writ of certiorari, which is a document that requires a lower court to surrender all of its case records. The judges of the circuit courts are nominated by the president and confirmed by the Senate and serve life terms. As you know, the Supreme Court is the court of last resort. We talked about that a minute ago, and consists of 9 judges appointed by the President and confirmed by the Senate. In order for a case to be heard, there must be at least 4 judges who vote to hear the case. When a case is scheduled to be heard, the attorneys file written arguments as well as briefs on behalf of other parties and experts called amicus curiae, or friends of the court briefs. For example, the ACLU or Amnesty International may file an amicus curiae brief in a case involving the death penalty or for someone who's mentally ill. State courts have more specialty than lower courts, and I will talk about this in, oh, well, okay. I didn't get all of these slides. Okay. Okay, state courts have more specialty courts or lower courts, such as domestic relation courts or divorce courts, drug courts, bankruptcy courts, and juvenile courts. State courts also include probate courts, which handle wills and estate distribution. Okay, and on to part 2.